On Law Weekly today, we bring you some compelling conversations we had in 2019, especially on issues which trailed the judiciary in that year. The start of a new year is always a good opportunity to look back at what has been and offer suggestions for improvements going forward. Welcome to Law Weekly on Channels TV and a happy new year to all our viewers. I am Shola Shoyeli. 2019 was a very eventful year for the judiciary. It was on January 12th that the news broke that the Code of Conduct Bureau had filed criminal charges against the then Chief Justice of Nigeria, Justice Walter Onnoghen, at the Code of Conduct Tribunal. Justice Onnoghen was facing a 6-count charge bordering on failure to declare his assets and operating a domiciliary account, amongst other counts. A statement by the spokesperson of the Code of Conduct Tribunal, Ibrahim Al-Hassan, said the charges were based on a petition signed by the Executive Secretary of the Anti-Corruption Research Database Initiative, Mr. Dennis Aganya. Justice Onnoghen was arraigned before the CCT on Monday, January 14, 2019. He was eventually convicted by the tribunal in April. The trial elicited a lot of reactions from many legal practitioners. In fact, a group of 20 senior legal practitioners started an intervention program which they tagged a Justice Reform Project. What is the project about? We talked to a senior advocate of Nigeria, Femi Atoyebi.
Now, from the things we've read in newspapers and the social media, the CJN has been charged or arraigned before the CCT for either making false declaration of his assets or refusing or forgetting to declare some asset after he had attained the office as CJN. There is also the statement credited to him, which interestingly he hasn't denied. His statement is also on the social media, in which he said or admitted, oh, I forgot to make certain declarations, or I made a mistake. I think we're all agreed on one thing, and that is that the judicial system is corrupt. And the level is pervasive. It's extremely worrying to us. And by the way, I would say to you that we're not just 20. That's just the people who started. Since then, we received a lot of calls in, messages of goodwill from a lot of our colleagues, both in the inner bar and outer bar. We have even received a lot of encouraging messages from people who are not lawyers, but who believe in the cause that we stood up for. It just happens that the core of this group started in Lagos, people of like minds. Now, what binds us together is not where you come from, but our value system. Those who try to argue that the judiciary, or indeed our profession, is not being corrupted, they are living in denial. We propose what we call a long-term, mid-term, and short-term reforms. Some that have to be done right now, some that will be done within the next 1 to 2 years, and some over 3 to 5 years. On the long term, for instance, you find out a lot of the reforms we'll have loved to prefer. We would have difficulties because of constitutional or legislative provisions that would not allow us to do that, would impede us from doing that. So in the long term, we hope to be able to take such steps as would assist in amending the various laws, including the Constitution. And so this is going to be not just for the 20 of us or the group, whatever size we may be, but we will need every good-minded Nigerian from all walks of life to assist in that. And of course, the major things we can do are, one, we need to begin to read the Riot Act to corrupt judges and lawyers. We need to set up monitoring committees. We need to find a way of getting feedback from the members of the public and other members of the bar who choose to do it right. So if you find a judge or a lawyer who's involved in those corrupt, who continues to be involved in those corrupt acts, we'll call them out.
For the better part of 2019, the group says it consulted and reached out to other stakeholders, and so will keep up their activities in this new year to see how their intervention, if any, impacts on the judiciary. Moving on now, election petition cases kept the courts busy for the better part of 6 months in the year 2019. We talked to a senior advocate of Nigeria, Fidelis Odita, on some of the legal issues that arose from the outcome of the election.
For losers in Nigerian election, the Nigerian electoral law is erected in such a way that it's almost impossible to overturn some of them, especially in the presidential election, because you need to prove that the malpractices were sufficiently material to affect the outcome. But where you've got over 200,000 polling units, the challenge of trying to get witnesses in all those within the 30 days or 21 days that you're required to file the election petition is simply too much for most people. It's not easy to see what we should actually do, but I think the burden placed on the person challenging an election results are huge and almost insuperable. Yes, in some cases they've succeeded, but if you analyze the cases where there's been success, whether at the level of a state assembly or the House of Reps or the Senate, you almost certainly find a basis for the outcome. If you're trying to challenge a result where someone won by 100,000 votes and someone is said to have lost in the same election by 80,000, so there is a difference of 20,000, it is much easier to demonstrate that there is overvoting of 20,000 than in the case where you've got a victor recording 15 million and then the second person or the loser, the main loser, scoring 11 million. So you need to show that 4 million or 3.9 million votes were improperly counted for that person. It's a tall order. And that's why it's easier to prove electoral fraud or electoral malpractice in relation to the Senate or the House of Reps, especially a state election, say state assembly where you could win by 20 or 30,000 votes. It's very easy to show that the 30,000 were manipulated and that you had 35 or something. But if you're trying to prove that instead of 11 million, you actually have 16 million or you had 14 and that the person who was awarded 15 should have had 12 or 13, you've got to try and prove about 2 to 3 million votes. It's not easy. You have to provide credible evidence with witnesses. And if you take, say, in the case of Maiduguri, Borno and Yobe, and you look at the figures that have been returned, if you aggregate the votes for APC, the votes are not up to 1.5 million out of a 3.9 million margin of victory. So you still have 2.4 million to contend with. So assuming you set aside all those votes, assuming they voted 0 for Buhari, you still have an enormous task of proving that the election did not reflect the true will of the voters. In saying that, I'm not at all saying that there were no malpractices. I'm just pointing out that the electoral laws have placed almost insuperable difficulties or hurdles in the path of successful challenge of a national election like a presidential election.
For another senior lawyer, Boma Ayomide Alabi, the country needs to amend the Electoral Act to make access to justice easier for litigants who are not involved in election petitions during an election year.
I'll give you an instance. Real life cases that we're dealing with where, a petition for a divorce, not contested. Both parties are living separately and have been doing so for over 6 years. As you know, it's a 2-year separation, and that's it. In a normal year, that should really have started and concluded within a matter of 6 months. Because this is an election year, all the judges, not all, but the majority of the judges in the state high courts, and so on, have been swept off out of the normal courtrooms into this election petition tribunal. If you think about it, there is no such thing as an election petition tribunal in the sense of a building or judges who are specialist election petition judges. They are taken out of this already overburdened system in order to deal with the election petitions, pre-election matters, and post-election within the time that has been provided by the law. That is a bad law in the sense that it doesn't take the citizen into consideration. The system is already overburdened. The judges are then moved into these election petition tribunals, and all the litigation that deals with the lives of ordinary citizens, their marriages, their businesses, commercial transactions, those who are charged with criminal matters who are awaiting trial, are effectively put on hold for the year. So if I was a Nigerian and I had to do anything in court, I would have to avoid the election year because nothing will happen. We have, I believe, a bill pending at the moment. If not, there should be. And we must take the citizen into consideration when they amend the Electoral Act. What is the impact of this, timeline? Because all the judges have to focus on those petitions to the detriment of citizen litigants who are not involved in election petitions. How can we ensure that we meet the objective of the election, the act, whilst not impacting negatively on the citizens? And it's not rocket science. In other jurisdictions, in England, for instance, they have part-time judges who are in practice. And so we could bring something like that into the mix to deal with that peculiar situation only, so that in the election year, perhaps, it's one solution, one that I'm proffering. It doesn't necessarily have to be the best one, but we have to look at it. Maybe senior lawyers, maybe registry, I don't know. But we must find a solution that ensures that the citizen has access to the courts and the matters are not delayed because of election petitions.
We wrap up with discussions on how the judiciary has impacted on the economy. We spoke to a former chairman of the Nigerian Bar Association section on business law, George Etomi.
Now, when I started out practice so many years ago, business law disputes were expeditiously dealt with. We can argue that the caseload was much lower, but it was very rare to have business law disputes go on for up to 2 years. In fact, people would generally scream. And it was also directly proportionate to the response of investors. And so we saw quite a high level of investment flow because there was certainty about how disputes will end up. But unfortunately, a mixture of an explosion in the economy, explosion in the population, which has directly impacted workload in the courts, has seen courts struggling to cope with business law disputes. And this is exacerbated by the advent of what you might call party politics. The good news perhaps is that you are beginning to get alternative dispute resolution mechanisms, and people are becoming more and more conscious of them. So ADR, it comes in different forms: mediation, arbitration, and so forth. But again, this sad spectacle with those ones is that disputes, especially on points of law, still go from those panels to the courts, where they can then, you get another round of delays. Even our special courts, like the IST, the Investment and Securities Tribunal, they're not faring better. So we need a holistic view about what our justice delivery system is designed to achieve from a business law perspective. And I think it's important that the NBA works with the judiciary to create a template that enables disputes surrounding businesses to be dealt with expeditiously.